down to business.
That's the nectar of the gods, baby.
Hello, everyone, and welcome to the #1 liquid-fueled, liquid-lubricated show on the interwebs. This is the Whiskey Musings broadcast. Boy, have I got a jam-packed informational show for you tonight. And I know this is a pretty big concept, a pretty big subject to kind of grasp. So I'm going to go as quickly as I can through everything. Hopefully I can fit it within an hour, but as you know, sometimes I do tend to go over an hour if things are really big and important. So stay tuned for that. So this, not this past week, but the week before last, Keith Olbermann, who is a CNN, or used to be a CNN sports commentator. I honestly, I don't watch the guy. I don't even know really, what he's doing today. But I do know that he used to be on CNN. He used to be a commentator, a sports commentator, and that kind of stuff. And he posted a video on Twitter that was focused on the Second Amendment. In particular, in his mind, well, it had to deal with the verbiage of the Second Amendment and what wasn't in it versus what is. Now, in specifics, he's talking about in the Colorado All-Star game, just before the game occurred, not like right before, but like a week or so before, the Colorado PD found a hotel room filled with a bunch of long guns and several rounds of ammunition. And they suspect, at least the last that I had heard, is that they suspected that the plot was to try and take people out and snipe people from that hotel room at the All-Star game. Now, the last that I had heard, there wasn't any confirmation of any of that, but that was the suspected use for that. And so, he kind of goes off on a rant with regards to the Second Amendment. So I've been thinking about this for a while. As you know, I am a proponent of the Constitution, and as such, I am also a proponent of the Second Amendment. Therefore, that's one of the reasons why I've been thinking about this show, but I kind of really haven't had an opportunity to necessarily put it out there in the proper context. And fortunately, Mr. Olbermann has given me the opportunity to do so. But before I get to that, I've got a couple of things that I need to say. First of all, thank you very much for those of you who have subscribed to my channel on YouTube. I do appreciate it. For those of you who are on the audio portion of the program on Spreaker and listening, actually might even be listening on places like Spotify, iHeartRadio, Google Podcasts, all of those places. Thank you very much for taking your time to listen to me pass on information to you, because obviously without you, I would not be doing this program. The other thing is that, and I'm attempting this, but supposedly I should be streaming to my Facebook page as well. So if you're watching me on Facebook, welcome. This is a trial. This is a first time deal for me, and so now it's not in my private page anymore. This is now actually part of my public page, which is actually pretty cool, because that obviously opens it up and sends it out to multiple more people than just those who are in my private personal account. So all of that is taken care of. I also have another announcement for tonight, and well, let me just go ahead and get right into it. I have been given the honor of being a brand ambassador for my next showing here. So if you honor and value our God-given right to self-defense by owning a firearm and would appreciate joining a community of like-minded individuals who welcome firearm owners of all experience levels, then you should consider joining the NCCA. The National Concealed Carry Association, NCCA, exists to serve the Second Amendment community by providing a nationwide network of Second Amendment advocates, offer elite self-defense and concealed carry training from the nation's top instructors, and provide rock-bottom prices on some of the best selection of gear and accessories. NCCA members enjoy shopping thousands of products with zero dealer markup, unlimited free shipping, and keep more money in their pockets with zero credit card processing fees. The NCCA encourages safe, responsible concealed carry and celebrates those who are brave enough to protect not only themselves, but their families and their communities. If this sounds good to you, visit nationalconcealedcarryassociation.com to join today. As a special bonus, use my affiliate link. That is, so go to your web browser and type this in the browser bar, ncca.refr.cc/Rick, RICK 02, and you'll receive a code for 10% off any purchase at nationalconcealedcarryassociation.com. Once again, use my affiliate link, ncca.refr.cc/Rick02, and receive a code for 10% off your purchase at nationalconcealedcarryassociation.com. Visit National Concealed Carry Association, all one word and all spelled out, all lowercase, .com to find out more today. Thank you, National Concealed Carry Association, for that spot and for the membership, or being a brand ambassador is what I'm called. So let's just jump right into it here. So I've got the Keith Olbermann video up, and it's a couple minutes long, so bear with it. But I want you to listen to what he's saying, and then I'll come back and we'll talk about it just a little bit. So let me go ahead and bring that up, and I will start it here.
Whether or not you meant to watch baseball's All-Star game, and who am I to judge you, remember that Saturday night police uncovered a stash of 16 long guns, body armor, and 1,000 rounds of ammunition in a Denver hotel room near where the game was to be played. And then the FBI said they had no reason to believe this was connected to the All-Star game, and a lot of people relaxed and took this as good news, as if it's somehow okay that 4 people had stashed long guns, ammo, and body armor for any purpose other than shooting up the All-Star game like it was Las Vegas 2017, as if that's the way it's supposed to be, as if anybody should have 1,000 rounds of ammo and body armor, and they could then ask their Denver hotel for a room with a balcony for whatever reason. So think about the All-Star game. Think about the Denver weapons stash a block away, which was either an interrupted All-Star game mass shooting or an interrupted non-All-Star game mass shooting, and consider again the holy Second Amendment to the Constitution and ask yourself this question. Why doesn't the Second Amendment have the word own in it? Why does it not say the right to own guns or any synonym for own? Why does it just say a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed? Keep and bear, not own. Keep doesn't mean own. Bear doesn't mean own. Yet by the same kind of logic that made lots of us breathe sighs of relief because maybe nobody meant to shoot up the fans at the All-Star game, our nation has been covered neck high in this bullshit that the Second Amendment makes gun ownership not only legal but sacrosanct. 103 times the Constitution uses words like ownership, value, purchased, receipts, property, private property, but not once does it do so in the Second Amendment, because the Second Amendment isn't about gun ownership, it's about regulation of state militias. Yet thousands of us die every year buried under this same bullshit. The same bullshit that says if the 1,000 rounds of ammo in the Denver hotel room wasn't there to kill baseball fans, that somehow that's good news.
All right. Thank you, Mr. Olbermann. So let me go there. All right. So there's a couple things. I mean, first of all, you know what? To give him credit, he is correct. He is absolutely correct. The term ownership does not show up in any of the 27 words that are used to make up the Second Amendment. And he gave it to you right there, a well-regulated militia, et cetera, et cetera. All right. So, here's the thing. And this is honestly, this is really where some of the challenges come into play with understanding the Second Amendment. First of all, it is only 27 words, and it was put in with the idea that that there would be. I'm having a little. Sorry for the skipping. I apologize, but so. The Second Amendment was put in there with the idea that it would be fairly obvious to most people. And so what I did is I actually went and did some research, and I kind of dug into, a couple of things. First of all, understanding a lot of times we look at things in the Constitution and we don't necessarily take them in stride with particular context. It's usually we just read the text and then we try to interpret what that text might mean. In actuality, you have to add context and you have to add contextual meaning to understand what is going on with with any of the amendments in the Constitution, to be honest with you. But the biggest key, of course, has to deal with the fact that most people look at the term well-regulated, and well-regulated is apparently, a challenge, because a lot of people think of regulated as being, under government control, under specific rules and things like that. And one of the things that I decided to do was I said, hey, has anybody actually done a study on what the term well-regulated means based on the fact that, looking at it from a contextual point of view? And to be honest with you, I looked around. 18th century English is not the same. 18th and 19th century English is not the same as necessarily in terms of meanings as what we have today. And you can see that even with some of our additional meanings that we have even in today's, today's language, and sitting there and looking at something in 2021 is going to look different than somebody way out in, 2035, 2045, 2055, even 2100, provided that we actually make it that far. Our language changes over time. And so one of the things that I did is I said, hey, has anybody ever done this study? Like I said, and I ran across a gentleman who, so I ran across a gentleman who basically did an analysis on the term well-regulated, because we obviously look at that and we think, hey, that started off the sentence. So let's take a look at well-regulated, meaning, under a lot of control. And he actually brought up, his name was Denton Bramwell, and he published this in August 6, 2007. And basically what he pretty much found out was based off of looking at writings from the 19th century and looking at how the term was used within those writings and then correlating those writings together. The term well-regulated actually meant more of on the lines of properly operating or in its ideal state, is what he says. And there's several items where he talks about this. And one of them, he looked at a writing by Anne Newport Royal. Anne Newport Royal commented in 1822 that Huntsville, Alabama was becoming quite civilized and prosperous with a fine fire engine and a well-regulated company. Okay. So, well-regulated company. And you could, kind of make the case, I guess, in a way he brings this up to that firefighters were subject to rules and laws. But the passage itself, if you substitute the term well-regulated with properly operating, and read it again, you would find the passage itself or the statement itself is a little more coherent. And he puts this into an example. They have a very fine fire engine and a properly operating company. Okay. Now, In William Thackeray's novel in 1848, he published where he uses the term a well-regulated person. The story itself is that of a character by the name of Major Dobbin, who has been, remiss with his family. And Thackeray's comment is that any well-regulated person would blame the major for this problem in terms of him not visiting his family. So based on, just those two examples and Denton goes through and actually lists several other examples, but I don't have time to go through them all. But he lists several other examples that basically indicate that anyone in the 19th century would read something that is well regulated as being properly operating in an ideal state, the best that it can be. So well regulated in the case of attaching it to the first statement in terms of a well regulated militia basically means that a properly operating militia is definitely what they mean. A well-oiled militia, well put together, well operating, operating appropriately, that kind of thing. So well regulated back in those days, I think you can hunt up, you can hunt up Denton Bramwell's article, but it's actually titled "Well Regulated Doesn't Mean What People Think It Does," and I think he provides several examples of what well regulated actually means. So if we go with the idea that well regulated does not mean, having a bunch of laws assigned to it, but actually well regulated meaning in proper working order, proper working condition, the best it's going to get. If we go with that idea, then obviously that negates any idea that the Second Amendment actually is attached to just the militia themselves having guns, having weapons. So if you take that out, okay, the next thing that I decided to do is I said, you know what? I'm not a lawyer. I am not a lawyer in any way, shape, or form. So what is it that I wanted to do? Well, I wanted to take a look at people who were in, and I'm going to pop this up, people who were actively, believe it or not, lawyers back in the 18th, 19th centuries. But before I do that, because I actually just messed up my order here. So hold on. Give me just a second. So before I do that, I also wanted to point out that the Second Amendment, its actual writing, the way that we know it today, was not what was originally proposed. And this actually, what you see behind me here on the screen, is actually the Second Amendment. It's notes that were being taken during the time that they were in committee, talking about the wording for each of the amendments. And this one happens to be from the 17th to the 20th of August in 1789. And the thing that threw me out, or the thing that caught my eye, was the fact that the Second Amendment was actually written much longer than the 27 words that we are aware of today. And so this, and I'm going to read this to you. So the proposition in the report was being proposed to the committee for writing the Second Amendment was, and I quote, "A well-regulated militia composed of the body of the people, being the best security of a free state, the right of the people to keep and bear arms shall not be infringed," semicolon, because this is important. "But no person religiously scrupulous shall be compelled to bear arms." Okay. Now, if you understand the makeup of the people that were out there at the time, the composite, most of the people that were out there had religious exemptions. For an example, the Quakers actually could not use their weapons in order to kill. They actually, to kill humans, they actually could only use them, according to their religious beliefs, they could only use them if they wanted to go and kill something for food. That's the only time that they could use it. So the original wording actually put in a potential exemption for someone who was religiously exempt or because of their religious beliefs could not be compelled or forced to bear arms. Now, the other piece to this puzzle is that even though that got argued back and forth, that really did. It got argued a lot. And that was actually the basis for most of the discussion in this committee, was talking about that. But Mr. Gary, Gerry, and I think his first name was Edward, but I'm not positive on that. But he basically, as a part of it, said this. He's like, this Declaration of Rights, I take it, is intended to secure the people against the maladministration of the government. If we could suppose that in all cases the rights of the people would be attended to, the occasion for guards of this kind would be removed. Okay, so what he's basically saying there is he's saying that if the government could be trusted to keep the people and the rights of the people in mind, then they wouldn't need this idea of a militia. But here's the thing that he goes on, but here's the part that really struck a chord for me. And that is, he goes on and he says, what, sir, is the use of a militia? It is to prevent the establishment of a standing army, the bane of liberty. Now, it must be evident that under this provision, together with their other powers, Congress could take such measures with respect to a militia as to make a standing army necessary. Whenever governments mean to invade the rights and liberties of the people, they always attempt to destroy the militia in order to raise an army upon their ruins. This was actually done by Great Britain at the commencement of the late Revolution. He's referring to the American Revolution. They used every means in their power to prevent the establishment of an effective militia to the eastward. The Assembly of Massachusetts, seeing the rapid progress that administration was making to divest them of their inherent privileges, endeavored to counteract them by the organization of the militia. Okay? So he's basically stating that the militia, the idea of the militia, because there was another part of the whole argument against the Second Amendment being for individual rights, was that the militia actually has turned into the National Guard of today. And that, if you weren't part of the National Guard, you very well couldn't have a need to keep these weapons around, especially in today's day and age. So here he's arguing, he's basically stating in no means necessary that the militia itself is to prevent the establishment of a standing army, which they don't believe in. Mr. Gary did not believe in this. And that the militia itself has to use the arms of the people in order to do its job, to basically do what it's supposed to do. And so the thing about it is that they basically just got away from fighting the largest armed force in the world at that time, which was the British Army and the British Navy. And what they did was a feat incredible. But again, I maintain the idea of the militia was for the protection of the people. And in this particular case, it is to prevent the establishment of the standing army. And it was also to prevent the government from overrunning and overriding the rights of the people. And this is really where the crux of the Second Amendment comes into play. There's been arguments that have been thrown out about the Second Amendment being only about hunting, but it's not. What it is it is based off of this piece, and I'll show you some more further evidence here coming up. But based on this, it was designed to basically state that they were scared of a standing army. They did not approve of a standing army. And this is true because George Washington actually disbanded the army after the American Revolution. And they didn't actually have a standing army, which was part of the problem because some of the soldiers from the American Revolution didn't get paid for their time while they were in the army. And that's what prompted them to go to Philadelphia. And that's what broke down, or was the trigger to break down, the Articles of Confederation, which was the precursor to the Constitution of the United States. So all of this is kind of tying together now as we start to take a closer look at what's going on here. So basically what he's saying, and what Mr. Gary continues to say, is that we can't, he starts arguing on the religious means. He wished that the words be altered so as to be confined to persons belonging to a religious sect scrupulous of bearing arms. And it kind of goes on and back and forth, but and they were focused mostly on the Quakers, or what they call the Moravians. Anyway, so they kind of go back and forth, but this beginning exchange basically shows you that, first of all, it gives us an indication of what the meaning was in terms of keeping the arms. These were arms that people owned. They were not owned by the government. These were expected by the militia members themselves, as individual persons were carrying. And these individual persons then brought those same arms into the militia. In fact, what's interesting is the first conscripted army members were of people who were sharpshooters. They were basically snipers, and they were conscripted into the army when the Revolutionary War started. And they came from militias made up of people, of just generic people running around. So this is an interesting little piece in terms of where he's talking about it. The sense that you get from this, obviously, is that arms were privately owned. Now, let's move on to the next guy. And let me just pop this up. Where is it? Okay. So I decided to take a look at a couple lawyer people, and, three of them in particular. We have William Rawle, we have Joseph Story, and we have Thomas Cooley. Now, all three of these individuals, they wrote either books or documents. Some of them were used in universities to talk to upcoming lawyers, and they were used to instruct upcoming lawyers. So this is coming from lawyers for lawyers. So these are explanations of the legal ramifications or the legal interpretations that are supposed to be used for these amendments. So here's the first one. This is William Rawle. And he was an American lawyer in Philadelphia. In 1791, was appointed as a U.S. District Attorney in Pennsylvania. He was founder and the first president of the Historical Society of Pennsylvania. And he was president of the Pennsylvania Abolition Society, and for 40 years, a trustee of the University of Pennsylvania. Okay. Well, he actually wrote a book. And give me just a second. I got to find it. Hold on. I want to get the title right. Come on. Okay. So he wrote, shoot. Okay. So he wrote a view of the Constitution of the United States of America. Okay. So he wrote this, back in originally the first publication that came out was, I believe, in 1883, if I remember correctly. Let me see. Yeah, that's not going to tell me. Oh, wait a minute. Sorry. 1825. Okay. So he wrote it in 1825 originally, the first edition. And so one of the things that he wrote about has to deal with the Second Amendment. And he goes through, he actually does a really good breakdown of the entire Constitution. You know, if you get the opportunity to grab this, grab it off the link, you should be able to pull it up and take a look. But here, deep down in the document, here's what he says. He says, in the second article, it is declared that, okay, and this is in italics, a well-regulated militia is necessary to the security of a free state. And then he puts a semicolon, unitalics. He says, a proposition from which few will dissent. Now, note the way that he's got this written, because he actually does put a semicolon in there, which essentially means that he's got two parts, two thoughts to the same sentence. Okay. So, and then he says, although in actual war, the services for regular troops are confessedly meaning confessed to be more valuable, yet while peace prevails, in the commencement of war before a regular force can be raised, the militia form the palladium of the country. They are ready to repel invasion, to suppress insurrection, and preserve the good order and peace of government. Now, I've highlighted this. If you're watching on YouTube, Rumble later, and on Facebook, I can't forget that. If you're watching this, take a look at the highlighted part. That they should be well regulated is judiciously added. A disorderly militia is a disgrace to itself and dangerous not to the enemy, but to its own country. Okay, now think about that statement. If that had to deal with laws and rules, he basically is saying that a well-working, okay, well-regulated meaning well-working. So well-regulated you're starting to see this, hopefully. It has nothing to do with laws that are attached to this, okay? So now, to continue, the duty of the state government is to adopt such regulations as will tend to make good soldiers with the least interruptions of ordinary and useful occupations of civil life. In this all, the Union has a strong and visible interest, okay? So what he's saying here is that it is in the best interest of the state to keep a well-regulated or properly maintained militia. All right. Now, the corollary, he continues, the corollary from the first position is that, and this is a italic part, the right of the people to keep and bear arms shall not be infringed. Now, he puts it in there. He says the prohibition is general. No clause, and this is highlighted for those on YouTube and Facebook, no clause in the Constitution could by any rule of construction be conceived to give to Congress a power to disarm the people. Okay? So he makes this statement basically saying that under no clause in the Constitution should the idea of Congress having the power to disarm the people. Okay? And he continues here, such a flagitious attempt could only be made under some general pretense by the state legislature. Now, this is interesting. He's actually basically stating that the federal government itself cannot have the power to disarm the people. That actually has to be made in the state legislature, meaning that the states themselves possibly have the power to take away your right to keep and bear arms. Okay. He continues here. But if in any blind pursuit of inordinate power, either should attempt it, this amendment may be appealed to as a restraint on both. So he's basically stating in this dissertation, and again, keep in mind, this was written in 1825. He is basically saying in this dissertation that the Constitution of the United States cannot, and Congress cannot, take away your right to keep and bear arms. Now, what do they mean by keep? You know, that was one of the things that Keith Olbermann kept talking about. Keep actually meant, honestly, it means to hold, to keep, to maintain, to make sure that it's in working order, because honestly, if they were depending upon the militia to defend the colonies initially, because again, keep in mind, they did not want a standing army. If they felt that the militias had to be ready at a moment's notice, there is no reason why you sit here and talk about the idea that personal ownership is not part of the word keep. I tend to think of keep as like keepsakes. If you have a keepsake, you not only own it, but you also maintain it because you have a vested interest in this thing to keep it, basically to have it nice and presentable and everything else. I mean, you're not going to go and destroy it. And the word ownership doesn't necessarily correlate with the idea of ownership and maintenance. Ownership, you just own something. You don't necessarily have to maintain it. Keeping gives you an idea that there is more to it than just owning the weapon. You need to, in this case, the weapon, but the item, whatever it is, you need to own it. You need to maintain it. You need to keep it in proper working order. You need to, make sure that it is able to do its assigned function. So the term keep, although Keith Olbermann talks about keep, it doesn't mean own. It actually, in my mind, it actually does. And it looks like from some of these, and you'll see as we get closer and closer to the end, you'll start to see what the idea, the meaning behind the whole Second Amendment was from the context of people in that time period. Okay. So that was William Rawle in his book. The next person that I have here is Joseph Story. Now, Joseph Story was an American lawyer and a jurist who actually served on the Supreme Court of the United States from 1812 to 1845 during the Marshall Court and the early Taney Court eras. He's most remembered for a couple of different opinions here, but he also had a book put out, and they've got it listed here, Commentaries on the Constitution of the United States, that was published in 1833. Okay, so keep in mind that the Constitution was put together in 1789. These documents are coming out several years later, but they are explaining the Constitution. Okay, and that particular book was dominating the field in the 19th century. This work is a cornerstone of early American jurisprudence. It is the second comprehensive treaty on the provisions of the U.S. Constitution and remains a critical source of historical information about the forming of the American Republic and early struggles to define its law. Okay, so this book that I'm about to show you was instrumental in the formulative years of defining what's going on with the Constitution of the United States. So here's an excerpt that I pulled from it. Okay. And the link is in the description on YouTube. So he basically kind of talks a little bit about having the militia being the natural defense for a free country. Against sudden foreign invasions, domestic insurrections, domestic usurpations by powers of the rulers. So, here again, you're looking at the foundational aspects of this particular scenario. And what you're seeing here is a common thread. They were scared of potential overpowerment of the federal government. And so the idea of the Second Amendment having anything to do with hunting is completely false, completely off its rocker. I don't even know where anybody got that idea. They obviously did not look back into the historical significance of these documents. Okay. So he says in this paper, he says it is against sound policy for free people to keep up large military establishments and standing armies in times of peace, both from the enormous expenses with which they are attended and the facile means which they afford to ambitious and unprincipled rulers to subvert the government or trample upon the rights of the people. So he literally is calling out the whole purpose of the militia is basically to defend the people against the government. I don't know how much more clearer anybody can actually get with what the reason of the Second Amendment actually is here. But I've highlighted a section here, and I want you to keep this in mind. So The right of the citizens, this is a quoting from him again, the right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic, since it offers a strong moral check against the usurpation and arbitrary powers of rulers, and will generally, even if these are successful in the first instance, enable the people to resist and triumph over them. Okay, so he literally is talking about people owning and keeping and taking these weapons and keeping them and having them at the ready at any moment in time to take over the government. So again, looking at this, I don't even know where the idea came from that the Second Amendment does not apply to making sure that the government itself is in check. And this is part of the reason why the left wants to take your weapons, because of this reason and this reason alone. Okay? So that was Joseph's story. So let's move on to my last guy, who is Thomas McIntyre Cooley. He was the 25th Justice and a Chief Justice of the Michigan Supreme Court between 1864 and 1885. He was born in Attica, New York, and he is a distinguished a charter member and the first chairman of the Interstate Commerce Commission. Okay, so he was a professor, he was a lawyer, he was a jurist. So again, these are not like just random people that are writing these things. These are people who have actually been educated in law at the period of time. Okay, so moving on to his book. And give me just a second. Let me bring that up here. This is the General Principles of Constitutional Law in the United States of America, first edition in 1880. Okay. So I got to get rid of that. He wrote this in 1880. So, this is the wrong thing. Sorry. That's coming up. Hold on. Let me get this. Like I said, I've got a lot here, and I want to make sure that everybody gets to it. So let me pop this up. Here we go. Okay. So way down in this document, toward the end, he goes through the entire Constitution, and I'm telling you, go through and read these things. They are impressive. But down here toward the end, he talks about the right to keep and bear arms. And what he says is, by the Second Amendment, the Constitution to the Constitution, it is declared that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. He says the amendment, like most other provisions in the Constitution, has a history. It was adopted with some modification and enlargement from the English Bill of Rights of 1688. Now, what's interesting here, and let me continue with this statement, where it stood as a protest against arbitrary action of the overturned dynasty in disarming the people, and as a pledge of the new rulers that this tyrannical action should cease. Okay, so what he's referring to in terms of the English Bill of Rights of 1688, basically back in 1688, the English actually wrote their Bill of Rights, and as a part of that, they mentioned that the right to keep and bear arms, but they actually broke it out into only Protestants could keep and bear arms without specific permission of the government. And so and this was actually referenced in a couple of the other articles that I was reading. The whole idea in the English Bill of Rights in 1688 had to deal with Protestants only. And anyone who wasn't a Protestant was viewed as being like a second-class citizen, and therefore could not, under any circumstances, keep and bear any kind of arms. So the idea was that the framers to the Constitution wanted to go one step further on that and just basically say everybody can own them, that there is no restriction on this. And he continues, Cooley continues here, the right declared was meant to be a strong moral check against the usurpation and arbitrary power of rulers, and as a necessary and efficient means of regaining rights when temporarily overturned by usurpation. Okay, So again, here we have a third person. Now, granted, they probably all, talked about their own works and stuff, which is what happens in law. But this is a third person who basically is agreeing that the idea of the Second Amendment really is about overturning a tyrannical government. Okay. Now let me scroll down just a little bit more, because I think there's more here. So he says the right itself is general. It might be supposed from the phraseology of this provision that the right to keep and bear arms was only guaranteed to the militia, but this would be an interpretation not warranted by the intent. Okay, so he's literally calling out the fact that just because the phrasing of the Second Amendment does not mean that this is only for the militia. Okay, he continues to support this statement by saying the militia, as has been elsewhere explained, consists of those persons who, under the law, are liable to the performance of military duty and are officered and enrolled for service when called upon. But the law may make provision for the enrollment of all who are fit to perform military duty, or of a small number only, or it may wholly omit to make any provision at all. So in other words, what he's saying here is that the idea that it's only given to a select few as a part of the militia is wrong. This is for anybody who can go and be part of service. Anyone who is fit to be part of the militia. It doesn't necessarily mean that you actually have to be a member of that militia. You can be conscripted to be brought into the militia at a later date. You might not even want to be part of the militia, but you might be asked to come and join the militia. So as an individual, and this is the key, as an individual who is not actively part of the militia, you have to have your own arm available. By that, you mean you have to have your own weapons, your own guns, your own ammunition. You need to have it in working order. Okay. He continues on this. All right. The meaning of the provision undoubtedly is that the people from whom the militia must be taken shall have the right to keep and bear arms, and they need no permission or regulation of law for the purpose. But this enables the government to have a well-regulated militia. For to bear arms implies something more than just mere keeping. It implies the learning to handle and use them in a way that makes those who keep them ready for their efficient use. In other words, it implies the right to meet for voluntary discipline in arms, observing in doing so the laws of public order. So, what does all that mean? Basically, he breaks it down for you. The individual right of the people to keep and bear arms shall not be infringed. Meaning that we, the people, individuals, have to be able to keep our arms available to us in case the militia, the state, needs our help in order to do several things. And he continues down here, even so far as, and here's another argument. So he continues talking about a standing army. So standing armies they were not well liked back then. Okay. And they did not, the people and the framers of the Constitution, they were abhorrent of a standing army. That's a big key here in understanding this Second Amendment. So then he moves on and he talks about what arms can be kept. Okay. The arms, and this is it quoting, the arms intended by the Constitution are such as are suitable for the general defense of the community against invasion or oppression, and the secret carrying of those suited merely to deadly individual encounters may be prohibited. So he does actually say that the type of arms can be prohibited. There is a possibility, okay, that they could be prohibited by law. But the fact that people can keep and bear arms that are not part of that, okay, that are not part of the prohibiting, of them that they can be prohibited, but it's only certain arms that he's talking about. In particular, the secret carrying of those suited to merely deadly individual encounters. So what he's talking about there is actually concealed carry. And honestly, there are prohibitions on concealed carry in most states. Unless they've gone and done constitutional carry, most states actually do require you to have some sort of a permit in order to be able to concealed carry. So there are laws that are already there, but the fact remains that we as the people have the right to keep, meaning own and possess, arms for the specific use of protecting ourselves and for possibly overthrowing a tyrannical government. Every single one of these documents talks about tyrannical governments and the act of the government being too tyrannical for the states. So this is really, honestly, where, I don't even know. I don't even know how you cannot call this out to actually understand the right to keep and bear arms is an inherent right. They expected people to own weapons and to keep them in working order so that they could be called upon, if necessary, for the militia. Now, this last piece that I've got here, and let me bring it up. This is actually something Samuel Adams, who was one of the framers of the Declaration of Independence, and also was a part of the Constitution. He also was a president at one point, or held a high office. I can't really remember. I believe it was president. It might have been John Quincy Adams, not Sam Adams, who was president. But the point is that he actually tried to make an amendment while they were talking about it in the Massachusetts state legislature. And he since pulled it out. He pulled it out afterward, but this gives you an idea of the thought process of these people at the time. And here it is. So he wanted to add the amendment that said, quote, "and that the said Constitution be never construed to authorize Congress to infringe the just liberty of the press," so he's talking about the First Amendment, "the rights of conscience," which it talks about religious freedoms, "or to prevent the people of the United States who are peaceable citizens from keeping their own arms." Or to raise standing armies, unless when necessary for the defense of the United States or of some one or more of them, or to prevent the people from petitioning in a peaceful and orderly manner. He kind of goes through most of the first several amendments. But the key here is that he talks about from keeping their own arms. Now, that amendment was rescinded, because of the fact that there was some objections. There were a lot of people who were thinking that back then that he was attempting to promote himself as a part of this. But the point being is the thought process was there. So I can't really see any deniable evidence right now that basically states that, first of all, number one, that the Second Amendment only applied to the militia. I think I've proved that it didn't. It did not apply to the militia directly. It was designed so that the people could form the militia, but it didn't necessarily restrict the arms ownership and bearing to the militia. It goes to the people. The second thought process that I have is in regards to the idea that well-regulated meant under many laws. No, it didn't. All it means, well-regulated only means that they need to be in working order. And the last piece of the puzzle basically is whether or not it is a right of the people that is given to us by the government, or is it something that we have for the government. And like I've told you before, the Constitution of the United States seriously shows that these are the rights that you as the government are not supposed to touch. You cannot do this. You cannot take away the right of the people to keep and bear arms. It also, I think I've also refuted the idea that the Second Amendment was actually written for hunting. It was not. It was written for the ideal state, first of all, that we didn't have a standing army, and second of all, that it was for the defense of the people, specifically against a tyrannical government. And this is why the Second Amendment exists. And this is part of the reason why the left, in particular, is really, really pushing to try and get rid of your arms. I think I've laid it out pretty explicitly in terms of what the meaning of the Second Amendment was and the thought process that went into it, the idea behind it, the contextual avenue from back in the 1800s and late 1700s, because again, 1789 was the Constitution. But the whole idea of what the Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is more than just a single piece of talking about a militia or a National Guard or anything like that. The idea, again, was for the people to be able to have their own arms to bring them to bear in the case of defense or tyrannical government. And that, my friends, is my final Whiskey Musings thought. If you like the program, do me a favor. Go and either subscribe on YouTube, check it out on Rumble, subscribe there. Obviously attached to my Facebook page. I would appreciate that as well. If you're on Spreaker or you miss a program or whatever, you can go ahead and go back, listen to the audio portion on Spotify, iHeart Radio, Google Podcasts, several other podcast outlets. For the most part, I'm not on Apple. I will tell you that I'm not on Apple yet. But as far as that is concerned, pass this around to your Second Amendment people, to people who believe in the Second Amendment and want to have a complete defense when it comes to a being able to defend against people who are gun grabbers, who are looking to grab your guns. Use this as an example. I mean, there are three people in particular. They are all well-known, well-authored. They were highly regarded and respected legal minds of the age that all spelled out the exact thing that I just did tonight. And take an opportunity to go and take a look at these things. Download them. They're free. You can grab them. I grabbed the PDF documents and read through them. There's actually a lot of information in terms of the interpretation of the Constitution. If we didn't already have things like the Federalist Papers and the Anti-Federalist Papers, these are just further resources to go and grab. And you can read through all three of them. In particular, is specifically what I've just shown you tonight. My goodness. Do me a favor. Also, don't forget to support the National Concealed Carry Association. I appreciate being a brand ambassador for them, and I hope that this was enlightening, informative, and as always, entertaining. You have a great weekend, and we'll see you next time on the Whiskey Musings broadcast. Good night, everybody.